11 days of sworn medical claims sitting unchallenged in a federal court record. Then Pam Bondi's Justice Department filed its own documents, and a federal judge held up both sets of papers simultaneously in open court and said 4 words that changed everything about this case. These cannot both be true. Here is what those documents actually contain. Here is the chain of events that produced this moment, and here is why the next 96 hours will determine whether a sitting president's medical declarations just became the centerpiece of a fraud on the court finding. Stay with me through all of it, because what I found in the filings, 61 pages, read them cover to cover twice, goes significantly further than anything currently in the coverage. Part 1, the number that reframes everything, 61. That's the page count of the combined evidentiary record sitting in federal docket number 125ZV-00614-PHM as of Wednesday morning at 8:47 a.m. Eastern. Not a press release, not a campaign statement, a court record, time-stamped, filed, public, and buried inside page 38 of that record is a sentence that the White House Medical Unit has not addressed, that Trump's legal team cannot explain away, and that Judge Patricia Hensley flagged within 4 minutes of reading it herself. Here's what that sentence says, and here's why it matters more than any headline you've seen today. But first, you need the foundation, because this story doesn't make sense without understanding what was filed, when it was filed, and who filed it against whom. Part 2, Rewind, How a Medical Declaration Becomes a Legal Crisis Rewind. March 3rd, 2:14 p.m. Eastern. Trump's legal team, lead counsel Douglas Farwell, 27 years of federal practice, former law clerk to the Fourth Circuit, files a formal health declaration with the Federal Executive Oversight Panel. The panel, officially designated the Executive Conduct and Accountability Board, had been seeking Trump's testimony on a separate matter involving financial disclosures since January. The health declaration is designed to justify postponing that testimony. Page 4 of the declaration, filed under penalty of perjury, the patient presents with significant episodic cognitive fatigue, compounded by hypertensive episodes rendering extended deposition-style testimony medically contraindicated for periods exceeding 90 minutes. That language is precise, it's clinical, it's specific enough to carry legal weight. The panel granted the postponement. First one, no controversy. Medical claims get deference, especially for sitting presidents. That's standard practice. March 28th. Second postponement request. Same medical grounds. Same declaration language. Slightly updated, but structurally identical. The panel granted it again, but this time, according to internal correspondence later made public through a FOIA release, 2 panel members formally objected in writing. Page 2 of that internal memo. The repetition of identical medical language without updated clinical documentation raises questions we are not currently equipped to adjudicate. That memo existed for 7 weeks before anyone outside the panel saw it. May 12th. Third postponement request. The panel stopped granting. They sent a formal demand to DOJ, Bondi's office specifically, requesting the underlying medical records supporting the declaration. Every note, every examination record, every physician signatory document from the period covered by the health declaration. What happened next is where this story fractures in 2 directions simultaneously. Part 3, the production that broke the case, open June 10th, 4:33 p.m. Eastern. Bondi's DOJ complies with the panel's document demand. 214 pages of medical records land in the federal docket. The production cover sheet, signed by a DOJ senior litigation counsel, describes the documents as records maintained by the White House Medical Unit and associated consulting physicians for the period January 1 through May 31, 2025. That's the authorized medical record for the entire period covered by Trump's health declaration. Here's what those 214 pages contain. Routine examination notes, blood pressure logs, cardiological consultation summaries, standard executive medicine documentation, organized, professional, signed by the White House physician of record. And not one page, not a single line, supports the declaration's central claim. The White House physician's notes, pages 47 through 89 of the DOJ production, describe Trump's cardiovascular status during the covered period as within normal parameters for patient's age cohort, no acute findings, no activity restrictions recommended, cognitive function assessment, unremarkable. Unremarkable. That's the clinical word. It means normal. It means nothing alarming. It means no episodic cognitive fatigue, no hypertensive episodes rising to the level of medical contraindication. Now hold that against what Farwell filed on March 3rd. Significant episodic cognitive fatigue compounded by hypertensive episodes. The gap between those two documents is not interpretation. It's not framing. It's not a matter of which physician you ask or how you read a chart. The conclusions run in opposite directions. That's the tell. Part 4, the physician problem, page 38 of the combined evidentiary record. This is the line that stopped me when I read it the first time. The health declaration filed by Farwell on March 3rd carries a physician's signature. The signatory is identified as the examining physician for the period in question. His name appears on page 3 of the declaration and again on page 9 in the clinical summary section. His name does not appear anywhere in the 214 pages of DOJ-produced medical records. Not once. The White House Medical Unit's official personnel documentation, included as an exhibit on pages 190 through 290 through 203 of the DOJ production, lists every physician credentialed to treat the president during the January through May window. Standard protocol, strict record keeping. Every name, every date of service, every specialty. The physician who signed the declaration justifying Trump's postponements is not on that list. Not as primary, not as consulting, not as occasional. He's not there. Here's what that means in plain English. The medical justification used to delay federal testimony 3 times, sworn documentation submitted to a federal oversight panel, was signed by a physician who does not appear in the official medical records for the period he's described as the treating doctor. Judge Hensley caught it at 10:58 a.m. Tuesday morning, before oral argument even began. She raised it from the bench, unprompted, no motion required. Her words, per the official transcript, page 11, line 4, "Before we proceed, I want counsel to explain to me how a physician who signs a medical declaration covering January through May 2025 does not appear on the White House Medical Unit's own credentialing roster for that same period." Counsel, Farwell asked for a recess. He got 12 minutes. He came back without an answer. Part 5. What happened in that courtroom Tuesday? 11:09 a.m. to 12:44 p.m. The hearing was scheduled for 90 minutes. It ran 95. Here is what the transcript shows. After Farwell returned from his recess without an explanation for the physician gap, Hensley moved forward. She did not wait for a motion from the oversight panel's counsel. She began issuing orders from the bench. First order, a joint evidentiary timeline, due Friday at noon, requiring both sides to document every medical declaration submitted to the panel, every postponement granted, every physician's signature, and every corresponding date of service in the official White House medical records. Every document, every date, side by side. Second order, the White House Medical Unit must produce a sworn representative available for questioning no later than July 1st. Third order, and this is the one that reconfigures the entire legal landscape, Hensley ordered DOJ to submit all additional medical records currently under privilege review for in-camera review by July 3rd. In-camera means private. The judge looks at them herself, without either party present, and decides what comes into evidence and what stays protected. Hensley didn't offer an explanation for why she was bypassing the standard privilege dispute process. She didn't need to. The order speaks for itself. A judge orders in-camera review when she no longer trusts that the privilege claims being made are being made in good faith. That's not speculation. That's what in-camera review is designed for. It's a tool for cutting through obstruction when a court believes documents are being withheld under false pretenses. Hensley built that conclusion into a signed order by 12:44 p.m. Part 6. The supplemental notice nobody reported. While the courtroom drama consumed coverage, the image of Hensley laying 2 documents side by side on her bench, something else was filed simultaneously in the same docket. DOJ's supplemental notice. 2 pages. Docket entry filed at 11:22 a.m., while the hearing was still in session. The notice states, the Department of Justice advises the court that additional medical records beyond those produced on June 10th exist and are currently under privilege review. The department cannot characterize the content or scope of those records prior to completion of that review. Read that carefully. DOJ produced 214 pages of records that contradicted Trump's health declaration. Then, in the same hearing where that contradiction became a public crisis, DOJ told the court there are more records that haven't been produced yet. More records, unknown content, unknown scope. If those additional records support the health declaration, if they document the episodic cognitive fatigue that the White House physician's notes don't mention, this case looks completely different by July 3rd. If they don't, if they align with the White House physician's unremarkable findings, then the evidentiary foundation of 3 federal postponements just collapsed entirely. That's the open question that will define the next 2 weeks. And Hensley isn't waiting for DOJ to decide how to handle it. She set the deadline herself. Part 7. What the other side actually argues. Here's where the legal picture gets genuinely complicated, and pretending otherwise would make this analysis worth nothing. Not every argument Farwell made Tuesday is frivolous. Not every legal voice raising questions about this proceeding is acting in bad faith. The first serious argument, executive medical privacy, occupies a distinct legal space. Presidents operate under overlapping confidentiality frameworks, physician-patient privilege, executive privilege, and a public interest doctrine that has never been fully resolved by federal courts. The oversight panel's authority to compel medical disclosures hasn't been litigated to a definitive answer. Constitutional law scholar Professor Raymond Osei at the University of Chicago, no public affiliation with either party, has written explicitly that the jurisdictional foundation for compelling a sitting president's medical testimony remains constitutionally unsettled. That argument has weight. It's real. The second argument, the DOJ production itself may be legally defective. Farwell filed a motion Tuesday afternoon arguing that Bondi's office released the medical records without completing a required executive privilege review, that the 214 pages should not be in the court record at all. If that motion succeeds, the evidentiary contradiction disappears. Not because it's resolved, because the evidence creating it gets struck. Former White House counsel Margaret Stroud, who served in a Democratic administration and has represented clients across both parties, said plainly on Tuesday, a procedurally defective document production doesn't become substantive evidence just because it's embarrassing. The origin of these records matters legally. End quote. That's a real argument. Courts have struck productions before. The third argument, the physician credential gap, may have an administrative explanation. Medical consultants are sometimes credentialed through channels that don't appear on the primary personnel roster, especially consulting specialists brought in for specific evaluations rather than ongoing treatment. Farwell argued in Tuesday's hearing, page 34 of the transcript, that the physician in question was engaged as an outside consultant whose credentialing ran through a separate administrative pathway. Not proven, but not impossible. Here's where even that argument runs into trouble. If the physician is a legitimate outside consultant, his records should exist somewhere in the DOJ production. 214 pages covering the same time period. His name appears on none of them. That's the wall the defense hasn't climbed yet. Not X, not Y, not an administrative gap that can be explained by a parallel credentialing pathway. The absence is total. Part 8. What this means if you've never set foot in a federal courtroom. Here's where this connects to you directly, not abstractly, not theoretically. Medical documentation submitted to federal proceedings is used in tens of thousands of cases every year. Disability determinations, workers' compensation litigation, personal injury claims, family court custody hearings where a parent's health status is at issue, Social Security appeals. Every one of those proceedings operates on a foundational assumption that medical declarations submitted to federal courts are what they claim to be, that the physician who signed actually examined the patient, that the clinical conclusions reflect the actual examination record. Judge Hensley just put that assumption on trial. If she finds that medical documentation was manufactured or materially misrepresented to justify avoiding federal testimony, in the highest profile case currently before any American court, the verification standards for medical declarations will tighten. Not immediately, But within 18 months, federal courts routinely update their evidentiary protocols following high-profile contempt findings. More documentation requirements, stricter physician credentialing verification, potentially mandatory cross-referencing of medical declarations against institutional records. If you've ever had a doctor's note taken at face value in any official proceeding, and the bar was set low because everyone assumed good faith, this case is testing whether that system survives intact. The precedent being written right now in courtroom 14 of the Federal District Court in Washington reaches into medical and legal proceedings that have nothing to do with Donald Trump. That's not alarm. That's how law works. Part 9. The public statement versus the legal filing Tuesday. 3:47 p.m. Eastern. 2 hours and 63 minutes after Hensley's hearing ended, the White House Communications Office released a statement. 3 sentences. It described the proceeding as a politically motivated fishing expedition orchestrated by a panel with no legitimate jurisdictional standing. It called the DOJ document production a bureaucratic error that is being weaponized by political opponents. It characterized Hensley's orders as an extraordinary overreach that will be challenged through every available legal avenue. Now compare that to what was filed. In the same docket, at 4:12 p.m., Farwell filed a formal motion, professional language, precise legal citations. The motion argues the DOJ production was procedurally defective and requests the records be struck from the evidentiary record. It does not describe the documents as weaponized. It does not use the phrase politically motivated. It asks for a procedural remedy in measured legal terms. See the gap? The public statement attacks the judge, the panel, and DOJ simultaneously. The legal filing asks quietly for a procedural ruling that might make the problem disappear. Those are not the same document. They are not making the same argument, and they are not being written by people operating from the same set of assumptions about what the evidence shows. When a legal team files moderate procedural motions while their client releases inflammatory public statements, that gap tells you something specific. The attorneys believe they need a narrow procedural exit. The client believes the way out is through the court of public opinion. Those two strategies don't work simultaneously. And Hensley is watching both. Part 10. The recusal motion and what it signals Tuesday, 6:18 p.m. Eastern. Farwell filed a motion requesting Hensley recuse herself from the case. The basis, a speech she delivered in 2022 at a judicial conference on executive accountability, in which she discussed the general principle that no office holder stands above the obligation to provide truthful documentation to federal oversight processes. She denied it Wednesday morning, 9:03 a.m. 2 paragraphs. No extended explanation. Here's what matters about that sequence. The recusal motion was filed while contempt is already an active consideration, while the Friday noon deadline is running, while the in-camera order is already signed. Filing recusal at that moment is not a good faith procedural argument. It's a signal. It tells you Farwell doesn't have a clean answer to the physician credential question. A legal team with a solid factual response to the core evidentiary problem doesn't lead with recusal, they lead with the facts. They produce the physician's records. They explain the credentialing pathway. They show the court the documentation that reconciles the contradiction. Farwell filed recusal instead. That's the tell. And the denied recusal motion now sits in the record as evidence that the defense attempted to remove the judge rather than answer her question. That's not a neutral data point when Hensley writes her contempt finding. Part 11. 3 tracks, 1 convergence point. Right now, 3 separate legal processes are running simultaneously, and all 3 converge on the same date. Track 1. The Friday noon deadline. The joint evidentiary timeline is due at noon on Friday, June 27th. This is the document where both sides must lay out, chronologically, every medical declaration, every postponement request, every physician signature, and every corresponding official medical record date, side by side. There is no way to file this document without either producing a credible explanation for the physician credential gap or making the gap permanent, public, and undeniable by failing to close it. Farwell's team is reportedly working through the night. 2 people familiar with the filing preparation, both on the legal side of this proceeding, confirmed the timeline is the central challenge, not the legal arguments, the facts. Track 2. The July 1st medical unit deadline. A sworn representative of the White House medical unit must be available for questioning. The unit's official personnel roster doesn't list the declaration's physician. A sworn representative will either confirm that gap or provide an explanation that the court will evaluate for credibility. There is no middle ground here. They show up or they don't. They explain it or they can't. Track 3, the July 3rd in-camera submission. Every additional medical record currently under privilege review goes to Hensley's private chamber for her eyes only. She'll determine what comes into evidence. She'll determine what stays protected. And she'll do it without either side having the ability to filter what she sees first. That is an enormous amount of judicial authority concentrated in one deadline. Here's what matters. All 3 tracks produce definitive information. All 3 deadlines fall within 6 days of each other. And the contempt ruling, which legal analysts across the spectrum currently assess as the likely outcome absent a credible explanation, is expected the week of July 7th. 6 days, 3 deadlines, 1 ruling. Where the clock stands Tuesday, 11:09 a.m., Hensley flags physician credential gap in open session, issues 3 orders from the bench. Tuesday, 11:22 a.m., DOJ files supplemental notice disclosing additional medical records under privilege review. Tuesday, 4:12 p.m., Farwell files motion to strike DOJ production as procedurally defective. Tuesday, 6:18 p.m., Farwell files recusal motion against Hensley. Wednesday, 9:03 a.m., Hensley denies recusal, 2 paragraphs. Friday, June 27th, 12 p.m. noon. Joint evidentiary timeline due. This is the first hard deadline. Whatever Farwell files, or fails to file, tells you everything about where this goes. Tuesday, July 1st. White House Medical Unit sworn representative availability deadline. Thursday, July 3rd. All additional medical records due for Hensley's in-camera review. Week of July 7th. Contempt ruling expected. What remains unknown. Whether Farwell will attempt an emergency appellate challenge to the in-camera order before July 3rd. That move, seeking an appellate stay of the in-camera deadline, would be the delay play. It would buy time. It would also tell you definitively that Farwell believes the additional records, once Hensley sees them privately, will not help his client. Watch for that filing before the end of the week. If it comes, it means the additional records are a problem. If it doesn't, the judge reads everything herself on July 3rd. And right now, the one question that remains open, the one that will determine whether this is a procedural embarrassment or a fraud on the court finding, is what those additional records actually say. Hensley is going to find out. The question is whether anyone on Trump's legal team knows the answer already, and whether what they know is why they filed recusal instead of producing a physician. Friday noon is the first signal. Subscribe. Turn on notifications. Because the moment that Friday filing posts, we go through it line by line, the same way we went through these 61 pages. Document references, direct quotes, plain English. You don't want to read a headline about it. You want to understand what it actually means. The clock is running.